Afternoon, ma'am.
Hi.
Mind telling me who you're visiting here today?
Visiting? I live here. This is my house.
Okay, you got any proof of ownership on you?
Excuse me, why would I need that?
HOA called in about a suspicious person sitting around out front. Just need to clear it up.
I can grab...
On September 14th, 2023, a homeowner sat on her own front porch in an affluent suburban neighborhood. Within an hour, she would be arrested, detained, and held for several hours without charge. 18 months later, the municipality would pay $1.8 million to settle her civil rights lawsuit. This is the story of how a routine afternoon became a constitutional violation and what it reveals about the boundaries between policing and civil liberty. It's a Thursday afternoon. The temperature hovers in the mid-70s. The neighborhood is quiet. Large homes sit behind professionally maintained lawns. Luxury sedans and SUVs rest in driveways. Trees line the streets. The Homeowners Association enforces strict architectural guidelines and landscaping standards. At approximately 4 o'clock, a woman sits on the front porch of her residence. She is in her late 40s. She wears black trousers and a sky blue button-down shirt. Her hair is neatly trimmed. A laptop sits open on a small folding table in front of her. She is reviewing documents related to her work. She has lived at this address for 7 months. She and her husband relocated from another state earlier that year. She works in commercial real estate and owns a small consulting firm. The mortgage on the property is current. Her name appears on the deed, utility accounts, and vehicle registrations associated with the address. She does not know that someone has called the police. Before we continue, if you're finding this content valuable, please take a moment to like this video and subscribe to the channel. We'd also love to hear from you in the comments. Let us know where in the world you're watching from. This reconstruction is based on patterns from real civil rights cases and investigative reports. Names, locations, and details have been changed. It is for educational and informational purposes only. Now back to what happened. At 4:12 p.m., a marked patrol vehicle pulls to the curb. A single officer exits. Body camera footage would later show his approach, steady, unhurried. His face remains off-screen. Only his hands, torso, and the surrounding environment are visible. He walks up the front path and stops at the base of the porch steps. "Afternoon," he says. "Can I ask who you're here visiting?" The woman looks up from her laptop. She appears surprised, but not alarmed. "I'm not visiting. I live here." The officer pauses. He shifts his weight. "Do you have any ID or documentation showing that?" She closes the laptop part way. Her tone remains even. "Why would I need to show that? This is my home." The officer explains that dispatch received a call from the Homeowners Association. A concerned resident reported a suspicious person sitting in front of the property. He states that he is following up on that call. At this moment, the legal framework shifts. What began as a consensual encounter, a voluntary exchange between a citizen and a police officer, now carries the potential for detention. The question is whether the officer has reasonable suspicion to justify further inquiry. Reasonable suspicion requires specific, articulable facts suggesting involvement in criminal activity. Sitting on a porch does not meet that standard. Neither does a third-party report lacking corroborating detail. The woman asks if she is required to provide identification. The officer does not answer directly. Instead, he repeats that it would help clear things up. She stands. "I'll get my driver's license. It's inside." The officer nods. "Go ahead." She enters the house through the front door. The officer remains on the walkway. Approximately 30 seconds later, she returns with a state-issued driver's license. The officer examines it. The address matches the residence. He radios dispatch and requests a verification check. Dispatch confirms the information. The license is valid, the name matches property records, and there are no outstanding warrants. At this point, the legal justification for the encounter has ended. The officer has verified her identity. She has demonstrated lawful presence. There is no evidence of trespassing, no indication of criminal activity, and no reason to prolong the interaction. But the encounter does not end. The officer hands the ID back and asks, "How long have you lived here?" "7 months," she replies. "And what do you do for work?" She hesitates. The question feels unrelated, but she answers, "I work in real estate. I own a small consulting business." The officer nods slowly. Then he asks, "How can you afford a house like this?" The question hangs in the air. It is not a standard verification question. It does not relate to identification, residency, or the original complaint. It is personal, speculative, and legally irrelevant. She does not answer immediately. When she does, her voice is quieter. "I work, my husband works, we saved, we bought a house." The officer does not apologize. He does not clarify. He simply continues. "Just seems like a big place for someone in your line of work." This is where the constitutional line blurs. The officer is no longer investigating a complaint. He is conducting an interrogation without legal basis. Under the Fourth Amendment, continued detention requires reasonable suspicion of a crime. Financial speculation does not qualify. The woman steps back slightly. Her posture stiffens. "Am I being detained?" she asks. The officer does not answer the question directly. "I'm just trying to make sure everything checks out," he says. "You've checked my ID. It matches the house. What else do you need?" The officer's tone shifts. It becomes firmer. "Ma'am, I need you to cooperate. If you're not willing to answer questions, that raises concerns." "I've answered your questions. I've shown you my identification. I don't understand what else you want." The officer takes a step closer. "I'm going to need you to stay here while I verify a few more things." "Verify what?" she asks. "You already ran my license." "I need to confirm ownership with the county." She shakes her head. "That's already on file. My name is on the deed. You can look it up." The officer's hand moves toward his belt, not to his weapon, but to his radio. "Ma'am, if you continue to obstruct this investigation, I'm going to have to detain you." The word lands like a gavel. She has not raised her voice. She has not threatened anyone. She has not refused identification. She has simply asked why she is being questioned on her own property. Under established case law, this is the point at which a consensual encounter becomes an unlawful seizure. The officer lacks reasonable suspicion. The original complaint has been resolved. Continued detention violates the Fourth Amendment's protection against unreasonable search and seizure. But the woman does not know this in the moment. She knows only that the situation is escalating. "I'm not obstructing anything," she says. "I'm standing on my porch." The officer steps onto the first porch step. "Turn around and place your hands behind your back." She does not move. "For what? What am I being arrested for?" "Failure to comply with a lawful order. Obstruction." "I complied. I gave you my ID. I answered your questions." The officer repeats the command. "Turn around, now." She complies. Her hands tremble slightly as she places them behind her back. The officer applies handcuffs. He recites no Miranda warning. He does not explain the specific statute she is alleged to have violated. He does not ask if she has medical conditions or physical limitations. He escorts her to the patrol vehicle. A neighbor across the street watches from a window. Another slows their car as they pass. She is placed in the back seat. The door closes. The vehicle pulls away. The laptop remains on the porch table. The front door is still unlocked. She arrives at the station at 4:47 p.m. She is processed as a detainee, not formally charged. Her belongings are inventoried. She is photographed. Her fingerprints are taken. She asks to call her husband. The request is delayed. She is placed in a holding cell. The walls are cinder block. A bench runs along one side. There is no window. She sits. She waits.
At approximately 6:30 p.m., her husband arrives at the station. He has been trying to reach her for over an hour. He spoke with a neighbor who saw the arrest. He drove to the station directly. He asks what charges have been filed. The desk officer tells him no charges have been processed yet. He asks when she will be released. The officer says it depends on the shift supervisor's review. At 7:53 p.m., the woman is released. No charges are filed. No citation is issued. No explanation is provided. She walks out of the station with her husband. She does not speak in the car. When they arrive home, the laptop is still on the porch. The door is still unlocked. She locks it. She sits on the couch. She does not cry. She simply stares.
3 weeks later, she consults a civil rights attorney. The attorney reviews the incident timeline, body camera footage obtained through a public records request, and dispatch logs. The attorney identifies multiple constitutional violations. First, the prolonged detention after identity verification constituted an unreasonable seizure under the Fourth Amendment. Second, the arrest lacked probable cause. Asking questions and asserting constitutional rights does not constitute obstruction. Third, the officer's questioning regarding financial status and homeownership exceeded the scope of the initial complaint and reflected investigatory bias rather than legitimate law enforcement purpose. A lawsuit is filed in federal court. The complaint alleges unlawful detention, false arrest, violation of civil rights under Section 1983, and municipal liability for inadequate training and supervision. The municipality's Internal Affairs Division conducts a review. The findings are not made public, but portions are disclosed during litigation. The review identifies procedural deficiencies. The officer failed to terminate the encounter after identity verification. The officer's questions regarding financial status were not relevant to the complaint and appeared to reflect subjective assumptions rather than objective investigation. The arrest was not supported by probable cause. The supervisor who authorized detention failed to review the legal standard for obstruction. 14 months after the incident, the municipality reaches a settlement. The agreed-upon amount is $1.8 million. The settlement includes no admission of wrongdoing, but it does require policy revisions related to homeowner verification, complaint assessment, and de-escalation training. The officer involved remains employed. He receives additional training. No disciplinary action is disclosed. This case is not an outlier. It reflects a documented pattern in how certain neighborhoods are policed and who is perceived as belonging. Homeowners associations function in many communities as informal surveillance networks. Residents report individuals they perceive as out of place. Dispatchers relay those reports to officers. Officers respond. The problem arises when perception replaces evidence. In this scenario, the original complaint was vague, a suspicious person sitting in front of a home. No allegation of trespassing, no report of forced entry, no description of criminal behavior, simply presence. When an officer arrives, they hold discretion. They can ask questions, they can request identification, but once identity is verified and no crime is evident, the encounter must end. Prolonging it without reasonable suspicion transforms a legal contact into an unlawful detention. The escalation in this case followed a predictable pattern. The officer's questions moved from verification to interrogation. He asked not just who she was, but whether she belonged. The shift was subtle but significant. The question, "How can you afford a house like this?" revealed an assumption. It suggested that her presence required additional justification, not legal justification, but social justification. That assumption is not unique. Studies of pedestrian stops, traffic enforcement, and complaint-driven policing show racial disparities in who is questioned, how long encounters last, and whether force or arrest follows.
Homeownership, in particular, has been a flashpoint. Legal cases across multiple states have involved black homeowners questioned while entering their homes, mowing their lawns, or sitting in their driveways. In each case, the initial complaint came from a neighbor or HOA member. In each case, officers prolonged the encounter beyond the point of verification. The legal standard is clear. Presence in a public or semi-public space, including one's own property, is not grounds for detention. Neither is a third-party complaint unless it includes specific facts suggesting criminal activity. But discretion is applied unevenly, and when it is, the consequences fall on individuals who have done nothing wrong.
The settlement in this case was paid by the municipality, not the officer. This is standard practice under doctrines of municipal liability and indemnification. Cities carry insurance. Officers are typically protected from personal financial consequences. This structure has implications. It insulates individual officers from accountability while placing the financial burden on taxpayers. Critics argue it reduces deterrence. Supporters argue it protects officers from frivolous claims. What it does not do is prevent recurrence. Policy revisions are common outcomes in settlement agreements. Departments update training protocols. They revise use of force guidelines. They implement bias awareness modules. But training alone does not address the discretionary space where these encounters occur. It does not change how complaints are assessed. It does not alter who is perceived as suspicious, and it does not eliminate the power imbalance inherent in a police interaction. Accountability requires more than revision. It requires transparency in disciplinary processes, independent review of complaint-driven stops, and legal consequences that extend beyond financial settlements. Without those mechanisms, the pattern continues. Across the country, individuals are stopped, questioned, detained, and arrested for behavior that is not criminal. They are asked to prove they belong. They are held without charge. They are released without apology. Most of these encounters do not result in lawsuits. Most do not generate settlements. Most do not appear in public records. They happen quietly, on porches, in driveways, at front doors. The question this case raises is not whether one officer acted improperly. It is whether the systems governing police encounters provide adequate safeguards to prevent abuse of discretion. The woman in this scenario received a settlement. She received financial compensation, but she did not receive an apology. She did not receive acknowledgement that the encounter should never have occurred. She received money, not justice, and thousands of others received neither. The lesson is not that policing is inherently flawed. It is that discretion without accountability creates space for violation, and that space is not distributed equally. Sitting on a porch should not require proof of ownership. Living in a neighborhood should not require social clearance. Asserting constitutional rights should not result in arrest. These are not radical principles. They are foundational. The question is whether they are enforced. If this analysis has been valuable to you, please subscribe to the channel for more content examining civil rights, legal accountability, and constitutional protections. Your support helps us continue this important work.